Hello everyone, thank you for watching the Fortis Law short video series. My name is Patrick Tan, CEO and founder of Fortis Law. In this video, I will be talking about the latest amendments and regulations regarding the COVID-19 Act in relation to real estate in Singapore. Since our previous videos on the COVID-19 Act, there has been a couple of key changes to the law. One of the key changes to the COVID-19 Act would be the definition of scheduled contracts, which has now been amended to include contracts such as A. Option to purchase agreements given by a housing developer, including HDB, to an intending buyer for the purchase of a unit of housing accommodation. And B. An agreement between a housing developer and a purchase for the sale and purchase of a unit of housing accommodation. Now this means that apart from parties in a lease or license for non-residential immovable properties, parties with residential immovable properties that fall under either of the categories that I mentioned earlier would also be allowed to serve what we call a notification for relief on the other party to the agreement should they face difficulties in meeting their contractual obligations. Upon being served with this document called notification for relief by the party who has not been able to fulfill his or her obligations under the contract, the other party, in this case, housing developer, cannot do any of this following. A. Increase or impose any charges or interest rates for interest payable unless it is specified in the contract, provided for or permitted in the contract or has been agreed between the parties. B. Require that any part of the security deposit be replaced except with the agreement of the non-fulfilling party. C. Withhold or forfeit any part of the booking fee or other consideration paid for the option. And D. Terminate the agreement between a housing developer and the buyer for the sale and purchase of a unit of housing accommodation. Apart from these key changes, in relation to the remission of property tax, a new regulation known as the COVID-19 Temporary Measure Transfer of Benefit of Property Tax Remission Regulations 2020 has been published to supplement the laws set out in the COVID-19 Act. In short, this regulation governs the logistics behind the property tax rebate that a tenant can expect to receive from the landlord. For instance, it determines the timeline for the owner-landlord to pass the property tax rebate onwards to the tenant and the information to be provided by the owner-landlord to the tenant. For property tax rebates relating to January 2020 to June 2020 leases, if the notice for the rebate amount for the property is served on the owner-landlord before 1st of June 2020, the rebate has to be passed on to the tenant by 31st July 2020. If the notice is served on the owner-landlord on or after June 2020, the landlord-owner has 60 days after the day of receipt of the notice to pass on the property tax rebate to the tenant. Similarly, for property tax rebates relating to July 2020 to December 2020 leases, if the notice for the rebate amount for the property is served on the owner-landlord before 1st November 2020, the rebate has to be passed on to the tenant by 31st December 2020. And if the notice is served on the owner-landlord on or after 1st November 2020, the owner-landlord has 60 days after the day of receipt of the notice to pass on the rebate to the tenant. I hope you found the information I shared with you useful and informative. If you have a query or require some assistance in relation to anything which I have covered in this video, please do not hesitate to get in touch with my law firm. Please subscribe to our channel for more videos and follow us on our Facebook and LinkedIn page to get updates on upcoming webinars. Stay safe, everyone.